What effect does public procurement law have on FinTech? Before going into our discussion, it's useful to know what FinTech or financial technology is. The thesis that I hope to convince you of during this presentation is that the way that FinTech law is structured right now is that it will probably lead to a free-for-all, not only between companies domestically, but also between companies and governments internationally. So let's look first at FinTech. By FinTech, we basically mean those distributed ledger technologies, which include blockchains, anything that can record in a satisfactory way a transaction. And undoubtedly, you've seen definitions of satisfactory way, meaning no double spending, meaning security, etc. So we don't go into that at all. Beside distributed ledger technology, FinTech has the possibility of using smart contracts in the future, which you can look up in the paper, and promote the use of tokenization, or the transfer of asset and obligation rights through electronic media. Looking at this kind of FinTech and the way these technologies have to disintermediate government and non-government activities as we know them now, let's look at kind of a typical complicated procurement. Procurement consists of numerous stages with numerous actors. Each of these spaces requires, of course, their own documents and pages to be filled in. But also, if you notice, in a lot of these nexes, a lot of these points, there is a place for finance. So there's either the cost of procuring the goods, there's the cost of assembling a tender. You can almost see each step of a procurement and each of the actors in this great big tree of what was later become known as decentralized autonomous organizations. You can almost see these as financing hubs. And the financing hubs then either come together under the aegis of one large organization like Morgan Stanley, or they're all disintermediated. You'll have a trade finance company deal with one particular aspect, maybe the transfer of goods from Miami to California by ship, or transferring the title and deed to particular government assets in case of sale, for example. So, looking more deeply, though, at FinTech and the effect that it will have on public procurement, you can think of anyone as basically sitting between government and business. So, FinTech promises to re-intermediate that relationship between government and business. If we've thought of capitalism before as the way of allocating resources toward either public ends or private ends through intermediaries, banks, then what happens when the banks disappear? And so if we look at each of these little financing nexes, what happens when they can all be done by the agents themselves? What happens when the institutions of capitalism no longer require the institutions? And so, of course, this leads to lower transaction costs and leads to a complete disintermediation, meaning that this distinction between government and business becomes less relevant and important in itself, doesn't it? Because if you're funding a swimming pool, for example, it doesn't necessarily matter whether you raise taxes or you just ask every member to contribute. It's basically, at its heart, just the same nexus of contracts. What is different about FinTech, though, is this idea of a common platform, is that there's some eBay type place that everyone goes to. There's some kind of web portal where I can lend you some money for the day, or you can transfer the tokenized rights to me over your car. And so it's that kind of one-stop shop. It's that one place that can handle this entire string of transactions that used to make up the procurement. And it's this platform which manages sometimes hundreds of contractors, subcontractors, and so forth. That's what makes this kind of fintech technology and the underlying nexus of contracts so very different than the capitalism that we used to know. What you've got to keep it in mind when thinking about fintech and thinking about public procurement is what is known as the contracting authority. That is the government body that's buying goods, services, and works. It's buying stuff, right? So scattered all throughout the public sector, there are these institutions that nominally, to greater or lesser effect, have to follow the rules of purchase that are laid down in law. They're often laid down in some kind of central buying authority's rules and in their own rules as well. So you can think of these contracting authorities as the heart of public procurement, thousands of little hearts beating, arranging the things that we need and use in daily life. And from a legal point of view, then, there's four kind of trade-offs that have to be made when thinking about how to regulate these things in this new platform world. If before we could think about the trade-off between rules and discretion, where each individual agency would have to follow some kind of certain minimum of rules subject to discretion, which maximizes public welfare. I mean, we can all agree that government purchases and government activity in general should maximize social welfare as defined in some way. But having this platform leads to the possibility of reducing discretion, fixing discretion in some way, or even transferring discretion to parties that before never had such discretion. It's entirely possible for a city to vote completely on whether they want a bullfighting rink or if they want a fountain, for example, something that was formerly delegated. Now people can direct their resources much more directly. The second trade-off is the extent to which each of these contracting authorities, each of these government bodies, represents a utility or whether they represent competitors. So if we're looking at a financing company that will carry the costs of my tender preparation, is that a public utility that all of us can use in order to make our bids cheaper, easier, better, and so forth? Or are we forcing onto a platform everyone to use that particular quote-unquote public good, despite the fact that there could be competition amongst various online service providers, thereby potentially increasing public welfare? And we just won't know that. We'll never see it. That's an area of this trade-off which you can't see until you see it, as it were. The third trade-off, kind of legal theory trade-off then, is the extent to which one discloses rules, discloses particular bid information for the good of the public or the good of the participating bodies, versus access to remedies. I can't know that someone's cheated unless there's enough transparency for me to observe that collusion has occurred, or that the contracting authority has agreed just to look the other way with regards to a deadline. And so getting that trade-off in a platform, right, where you have discretion and you have a potential public utility operating at the same time, it's not clear where that line of demarcation finally falls. Finally, the fourth kind of demarcation battle in this new platform economy of fintech and public procurement lies at whether a fintech in public procurement is simply an administrative service or whether it's a policy objective in itself. Remember that the promotion of national innovation, the promotion of even fintech as a 21st century technology has been stated by probably at this point most governments as a technological policy objective. It's not just a way of doing things. It's not just a stapler or a pencil or something used in office life. It's an actual aim in itself. But on the other hand, it is like a stapler. I mean, something which helps you reduce the costs of preparing a tender or involving doing background research on potential subcontractors. Those things they're good old boring bureaucratic basic costs office stuff, right? So to what extent does the development of a fintech-enabled public procurement, does that promote a policy objective, or is it just like e-procurement? Those are some of the legal lines of demarcation, but sitting on top of that, you have governments actively trying to promote a fintech. And in the paper, we talk a little bit about the international organizations which have been pushing this for some strange reason. We talk about LB Chain, Lithuania's big push to using blockchains in order to try and make their government better in some way. And if you scratch deep enough at any of these programs, you find that it's a lot of blah, 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 but not a lot of results. And so as of the end of 2010, we still see a lot of hype. We still see a lot of supposed results. But when you actually do the research, nothing's been done. So what we have is these contracting authorities, thousands of them, hundreds of thousands if we're looking at a space like the EU. Even now it's a free-for-all. When we're talking about something that becomes like eBay, very much becomes a free-for-all. It very much becomes a possibility that one particular ministry, the Ministry of Finance in particular, can overwhelm, completely dominate the conversation about how both fintech and public procurement should evolve. Yet, that's often where the authority and the work for fintech lie erroneously, in our opinion. So we have a domestic free-for-all, we have an international free-for-all, which we'll talk about in a little bit, but there's several ways of dealing with this potential free-for-all. The first way, of course, is to fight fire with fire, is to say, well, if we have a decentralized fintech for public procurement with each government entity organizing its own fintech around its public procurement, then why aren't they also responsible for having a decentralized supervisory technologies or other types of automated processes of overseeing the potential risks of them basically creating their own public procurement regimes? And that's been often flouted as one cure for this potential free-for-all. In the paper, we argue that this is impossible and extremely costly, and it's not the way forward. We argue for something akin to a fintech law, something operating at the legislative level, which is focused on public procurement and rethinking how public procurement works in the face of these enormous decreasing cost to scale to the completely different economics of government production than we've seen in the past. The two major international agreements on public procurement are the GPA, the General Agreement on Procurement, and the UNCITRAL rules governing public procurement, which most governments have adopted. And combined with that, we'll never see FinTech having any real effect on the current public procurement regime until we see liberalization of financial services under something like a GATS, a general agreement, or some kind of liberalization of the trade in services. And the way it looks right now is that we're not going to see any movement on either of those. We argue that's a problem because there is a dominant player who's going to set the rules if we just let the status quo continue as it is, specifically China. China's Belt and Road Initiative basically applies Chinese public procurement law to, 23 countries outside and encourages the adoption of those rules in those countries. Some might say even to the detriment of the UNCITRAL rules, though that's up for debate, in the same way that people have been crying and arguing about the extent to which the Multilateral Development Bank procurement rules have somehow infiltrated the development of public procurement rules nationally in developing economies. Now, that in itself wouldn't be such a big problem, but China also dominates the financial side of this equation, which is the online payment space. We're looking at Alipay, we're looking at Ant, Tencent, we're looking at companies that we don't even know about for reasons of national security. And what we see is that these finance companies, who often finance the purchases of their own goods on their own websites across borders, have the very real potential to completely dominate international payments. So China gets kind of the double win, right? They get the Belt and Road, which gives them quote-unquote control over the public procurement rules, and they get the online finance piece, which gives them control over payment of any government goods and services. So one might see China then as the de facto provider of rules in the cross-border procurement space. And in the paper, what we recommend is the development of an international public procurement authority. It's amazing. Most international issues have their own secretariats or bodies, except public procurement. With the creation of this international public procurement authority at the international level, and with the supercharging of national purchasing bodies or public procurement authorities at the national level, those two fixes should hopefully solve this free-for-all problem that we identify in the paper. And failing to do that, what we'll see is just a mess of fintech solutions. We'll see a mess of loopholes around procurement. We'll probably see countries look inward rather than outward as they try and create their own domestic platforms in race to be the biggest and best, fastest, and international welfare decreasing.